हेलो दोस्तों, अगर डिक्टेशंस पसंद आएँ तो लाइक, शेयर और सब्सक्राइब ज़रूर कर दीजिएगा। अगर आप इस चैनल पे नए हैं तो लाल रंग का सब्सक्राइब बटन है, बेल के साथ दबा दीजिएगा ताकि आपको आने वाली डिक्टेशंस टाइम टू टाइम समय पे मिल सकें। थैंक यू।
Start. This application is for reopening the review petition in bracket criminal number 308 of 2011 and for review of the final judgment and order dated 24/2011 passed by this court dismissing criminal appeal number 379 of 2009 filed by the review petitioner and confirming his conviction inter alia under sections 201, 366A, 376 and 302 of the Indian Penal Code IPC and inter alia affirming the death sentence imposed on him under section 302 of the IPC full stop para. It appears that the petitioner, a mason, was engaged at the residence of the deceased victim's grandfather full stop on 28/9/2004 at about 2 p.m. The petitioner gave money to the victim to bring betel for him from Hanuman Chowk full stop. A while later, the petitioner also went to Hanuman Chowk, picked up the victim, an 8-year-old girl, on his bicycle and left talking with her full stop. The victim and the petitioner were seen together by witnesses full stop para. The victim did not return home, whereupon frantic searches were made full stop. The victim was not found. It was learnt that the victim had been last seen with the petitioner full stop para. The officer in charge of Bahera village police station, under which the village of the petitioner falls, was informed that the victim was missing full stop. In course of investigation, the petitioner, who had earlier been identified as the man with whom the victim had last been seen riding on a bicycle, allegedly made a confessional statement in the presence of witnesses, confessing that he had raped and murdered the victim full stop. The confessional statement was signed by the petitioner full stop para. The petitioner is alleged to have disclosed the place where he had raped and killed the victim full stop. It is the case of the prosecution that on the basis of information given by the petitioner, the investigating officer went to the village Izar Hathband, where the dead body of the victim was recovered from the spot shown by the petitioner amidst wheat and arhar fields full stop para. The dead body was identified as that of the victim full stop. The doctor who conducted the post-mortem opined that death was due to asphyxia and hemorrhage as a result of strangulation within 8 to 24 hours from the time of post-mortem examination full stop. The doctor also deposed that upon examination, the vaginal swab collected from the victim showed few intact spermatozoa full stop. The medical evidence clearly established that the victim had been raped and murdered full stop. However, no DNA analysis of the spermatozoa was conducted by the prosecution full stop para. By a judgment and order rendered on 29/5/2007 in sessions trial number 220/2004 arising out of GR number 325/2004, Manigachi PS case number 13 of 2004, the additional district and sessions judge in bracket fast track court number 30 on consideration of the evidence on record held the petitioner guilty of charges under sections 366A, 376, 302 and 201 of IPC full stop. On the same day, after hearing the applicant on the question of sentence, the fast track court sentenced the petitioner to undergo rigorous imprisonment for 10 years for charge under section 366A IPC, rigorous imprisonment for life for charge under section 376 IPC, rigorous imprisonment for 7 years for charge under section 201 IPC.